Recording. Good morning. This is Michele Zaragoza, team leader, Stockton, Lodi, Tracy, Manteca, Modesto, all the above in Central Valley. Very, very excited to have Gov Hutchison finally here. So, Gov, share your knowledge with us, please. There's so much we have. We have so
Okay.
many questions, I should say. So many questions.
Yeah. Now, do you want to, when they ask a question, you want people to just answer? They can ask while I'm talking and put it in chat if you
This
want.
is 100% up to you. We can watch chat and we can, yeah,
Yeah, I
definitely.
mean, I'll watch it. I'll watch it myself.
Okay.
Yeah. And Michelle, how long do you want me to go? How long do you want me to talk?
We could go an hour. That's up to you.
Okay. Well, we'll see. Good morning, everyone.
Good morning. You guys can
Is it?
unmute and chat.
Yeah. Okay. I just want to, I think you know who I am. I'm your lawyer at CAR. We're busier than ever. We've had more phone calls to the legal hotline than ever before. And I think the whole buying season is sort of extended. Usually things start to slow down in September, but it's certainly not slowing down this year. And there's a lot of legal stuff to tell you about, a lot of legal changes. There are some new forms and there's a couple new laws and there's just new stuff. So let me just go into that, and you can ask questions on chat anytime, and I'll look at those and I'll just take them as they come. So first of all, let's talk about brand new laws. There's a really important new law that got signed on the 1st of September. It's probably the most important law that's going to get signed this legislative session, and that's the Tenant Relief Act. There's this new eviction law. You've probably heard about it, but let me just go over the highlights of it in case you're not sure about it. It's very complicated. First of all, you remember how the courts were closed for evictions all from March all the way through end of August. So you could not do an eviction in California. You couldn't do a commercial. You couldn't do any evictions in California until September 1st. Then September 2nd, the courts are back open for evictions. But right away, the government passed a law restricting evictions again. So the courts are open, but there's now a law. So what does this law say? Well, first of all, it doesn't apply to commercial. Anything doing commercial is normal. Well, what about other types of evictions? Well, if somebody does something wrong other than not pay rent, you could evict them right now. In other words, if someone breaks any term of their lease, they cause damage to the property, they sublet without permission, they have pets without permission, they create a nuisance, criminal activity, or something like a seller refuses to leave at close of escrow, or a tenant doesn't allow you to show the property in the circumstance. If any of those things happen, tenant does something bad, or seller refuses to leave, you could evict them right now. But what if you want to evict them because they're not paying their rent, right? What about that? Can I just evict someone now for not paying rent? No, it's not so simple. For the next 5 months until February 1st, let's say I want to evict someone for not paying rent. Do I send them a 3-day notice to pay or quit? No. I send them a 15-day notice to pay or quit. Guess what? The 15-day notice form just came out today. I think it's on zip form right now. In other words, if I'm a landlord, residential property, including mobile homes, including mobile home parks, in other words, this applies to you're renting a space from a mobile home park, or you're renting a space from a mobile home in the park. It applies to this and all residential rentals. If the tenant's not paying their rent, you got to send them this 15-day notice to pay or quit. And they have 15 days to respond, obviously, and you don't count Saturdays or Sundays or judicial holidays. So I sent them this form, and attached to this notice is this declaration of COVID financial distress. So if I send my tenant, so let's say the tenant doesn't pay the rent. They didn't pay the rent in April, May, June. So I send them this 15-day notice to pay. If they return this declaration within 15 days, signing under penalty of perjury, that they have a COVID reason they're not paying the rent. Either they've got a loss of income because of COVID, or they're sick themselves, or they're taking care of someone who's sick, or they've had increased expenses because of COVID. If they sign that declaration and send it back to me, the landlord, within 15 days, I cannot evict them. They still owe me the money, but I can't evict them. When can I evict them? Well, February 1st is when you're going to be able to do evictions for non-payment of rent. But for non-payment of rent between March 1st of this year and February 1st of next year, I cannot evict them for that ever. All I can do is sue them for the money. So once again, any rent owed by a tenant between March 1st of 2019 and February 1st of 2021, 2021, that's 11 months. If they have a COVID reason they didn't pay and they sign this declaration form, I can never evict them for that. Now, here's what's interesting. Starting September 1st, even if they have a COVID reason, they have to pay 25% of the rent. So let's say I'm a landlord, I got a tenant, and he hasn't been paying April, May, June, July, and sure enough, he didn't pay in September either. If I want to try to evict him, I have to send him one notice for the rent that he owed prior to September 1st, and a different notice for the rent that he owed starting September 1st, because starting September 1st, he's got to pay 25%. Even if he has a COVID reason. Up until September 1st, he didn't have to pay anything. So it's a different 15-day notice. You see what I'm saying? There's a 15-day notice to pay the rent that was due before September 1st, and there's a 15-day notice to pay the rent that you didn't pay after September 1st. And after September 1st, they have to pay 25%, even if they have a COVID reason. So what if my tenant didn't pay rent September 1st? They didn't pay anything at all. I send them the 15-day notice, and they pay at least 25%. Well, then I can't evict them. They owe me the money, but I can't evict them, assuming they return the declaration. What if they return the declaration, but they don't even pay 25%? I can evict them, but not until February 1st. If they pay the 25%, I can never evict them for that 75% they didn't pay. But if they didn't pay the 25%, at least I can evict them on February 1st. Now, all that money that they owe me, they got to pay me back. Did you know I could sue them right now in Superior Court for back rent? I wouldn't do that. You know why? The courts are so backed up, you're not going to get a court date for a year. And on March 1st, you can sue any tenant for back rent in small claims court, no matter how much they owe you. So the $10,000 normal limit on small claims doesn't apply anymore if you're suing for back rent. And that's for the next 5 years. You can sue for back rent in small claims, even if it's more than $10,000. But you cannot evict a tenant for non-payment of COVID-related rent. In other words, any rent they didn't pay between March 1st and September 1st, if they return that COVID declaration, any rent they didn't pay above the 25% starting September 1st, I can never evict for that. If they don't pay the 25%, I can evict on February 1st. And of course, I can evict in February if they don't pay the rent in February, whether they have a COVID reason or not. This is very complicated stuff. It's so complicated that if your client starts asking these questions, you know what advice you give them? Talk to a California real estate lawyer. I'm not going to explain this to you. I'm explaining this to you so you know. Some of you might be landlords, some of you might be tenants. I want you to know I'm your lawyer. But don't give this type of advice to your clients. We do have a Q&A on this on our website that explains all this. You can give them that if you want, but don't explain all this stuff, okay? All right. So forms coming out today, these two 15-day notices to pay rent or quit. plus this declaration of COVID financial distress also coming out. That's going to be attached to the 15-day notices. And what about this? What about the tenant, they pay the rent, but they owe you money for something else? They need to replenish the security deposit. They owe you for utilities they didn't pay or something like that. They owe you money other than rent. Same thing. You got to send them a 15-day notice to cure covenant of financial obligation. So there's 2 more forms coming out. They came out today. Not just the 2 15-day notices to pay rent or quit, but 2 15-day notices to cure breach of covenant to pay a different financial obligation. So 4 different 15-day notices came out, and this declaration that's attached to it. In other words, for the next 5 months, do not use a 3-day notice to pay rent or quit. You can still use a 3-day notice to evict someone if they did something else that was wrong. But if they didn't pay the rent, send them the 15-day notice. Now, what if in 15 days they don't respond with the declaration? You could evict them right now. Actually, you can evict them starting October 5th, which kind of works out, right? Because the forms came out today. So if I send them a 15-day notice today, what's 15 days from today? Well, I would say it's October 5th, but you can't count Saturdays and Sundays, so it's going to be more like the 9th. So the point is, you send someone a 15-day notice to pay rent or quit today. They don't respond with this declaration under penalty of perjury. You could start the eviction 15 days from now, not counting weekends, which I think would be October 9th. If they're doing something else wrong, give them a 3-day notice today, and you can go through the process, okay? One more way to evict someone. Can I evict someone just because, they're paying their rent and they're not violating anything else, but I just want to evict them because I'm bored with them, I want a new tenant. Can I do that? No. For the next 5 months, you need just cause to evict someone. Well, yeah, Gov, I know that's California law, but that doesn't apply to single-family homes or new construction, right? Nope. Up until February, the California Just Cause 1482 rent control law applies to everything, single-family homes and new construction. Which leads to the question, under what circumstances can I evict a tenant right now, assuming they're paying the rent and assuming they haven't done anything else wrong? Here are the reasons. Number 1, you want to move in yourself. You can evict them. You or a family member, parent, child, grandparent, grandchild. Number 2, you want to take your house off of the rental market. Say, I'm not going to be a landlord anymore. Then you can evict someone. But you know what the problem with that is? If you sell the property, the buyer can't rent it out either. Maybe they don't want to rent it out, but I'm just saying. You can evict someone if you take your house off the rental market, but that means the house itself is off the rental market for the next few years. But here's the good news for you. You can evict a tenant right now if you're selling the house to a buyer who wants to live there. You have to wait until you're in contract. So let's say you have a listing, right? That you're a seller, you've listed your house, and you had a tenant in the property. You can't evict that tenant yet, but once you get a buyer who makes an offer, then you accept it, so you're in contract with the buyer. And they want to live there. They write on the purchase contract, they will occupy. You could give that tenant now a 30-day notice or a 60-day notice. Okay, so that's the good news for realtors selling tenant-occupied properties. You can evict them as soon as you're in contract with a buyer. Doesn't matter whether they're paying the rent or, you know what I mean? Even if they're paying the rent, even if they haven't done anything else wrong. So owner move in, selling the house to a buyer who's going to live there, or taking the house off the rental market. I probably wouldn't do that, because then you'd be restricting any buyer. Some buyers say, I don't want to lose the right to rent this out in the future. So I'm saying the only way you're really going to give people these no-fault notices are, number 1, you want to move in yourself, or number 2, you're going to sell it to a buyer who's going to live there. Those are the two ways to evict someone for no fault. Once we get to February, we're going to be back to normal. But right now, you're a little bit restricted on evicting. What about a substantial remodel? Can't I evict because of a substantial remodel? Not until February. If you want to evict for a substantial remodel now, it's got to be a remodel necessary for health and safety reasons. Okay? All right, almost done with this. What about this? There's a whole nother form you got to worry about if you're a landlord. Listen to this carefully. If I'm a landlord and my tenant is behind in their rent, even if I'm not going to give them a 15-day notice, I said, "Ah, the heck with it. They got this COVID thing. I'm not going to do anything till February." Even if you're not planning on giving them a 15-day notice, if you have a tenant behind in their rent between March 1st and September 1st, you have to give them this disclosure form disclosing their rights. It's called the NTRA, Notice Regarding Tenant Relief Act. This form has been on zip form for a week already. If you're a landlord, give this form to your tenant before September 30th. What if I'm going to give them a 15-day notice today? Well, then attach it to the 15-day notice. Don't wait till September 30th. So your deadline to give this form to a tenant behind in their rent is either September 1st or when you give them this 15-day notice. So if you're going to give them a 15-day notice before September 30th, attach the NTRA form to your 15-day notice. If you're not going to give them a 15-day notice before September 30th, give them the NTRA form before the end of the month. Okay? So those are the forms you got to deal with. There are a couple other forms that came out today that are not mandatory. You know the concept of cash for keys? Thankfully, that's still legal. In other words, no matter what situation a tenant's in, if they're willing to leave for money, you can do that. And guess what? We just came out with a cash for keys form. It's called a rent forgiveness in exchange for possession form. Just came out today. So that's a good form. And then we also have a rent repayment agreement. Maybe the tenant's gonna agree to pay you back the rent. Hopefully they will. Or you can wait till March 1st and sue them in small claims court for all the money they owe you. There's no rent forgiveness here. Everyone has to pay back the rent. It's just there's a delay. You can't evict them until February if they submit this declaration. Okay? Before we go any further, I think there are a couple questions. Yeah, the rent from April to September they don't have to pay the 25%. But 25% is starting September. Starting February 1st, they got to pay all the rent. So if you're a landlord and they don't pay their February rent next February, no matter what the reason is, you can evict them. Okay? All right. Anyway, couple more things real quick. Does the tenant have to prove to you that they actually have a COVID reason to not pay the rent? Nope. All they have to do is sign the declaration under penalty of perjury, unless it's a high income tenant. What's a high income tenant? They make 130% of the median income in the county you're in. How do I know what 130% is, and how do I know how much money they make? Well, you can look up online what the median income is for your county. Well, how do I know how much they make? Well, you have to base it on the information they gave you when they rented from you. So 3 years ago, as part of their rental application, they told you what their income is. Based on that number, is that number more than 130% of today's median income? If so, then you can demand on your 15-day notice, you can check a box that says, since you're a high-income tenant, you need to provide me within 15 days of documentation showing that you've lost income because of COVID or you have extra expenses because of COVID. If they're not a high income tenant, all you're entitled to is them signing under penalty of perjury. Okay? Complicated stuff, but that's all the forms that you need to know. That's the law you need to know. Last question people ask me, I heard there's this national federal government eviction moratorium. Is that true? Yes. Well, how does that interact with the California one? Well, the federal law says no evictions until the end of the year, residential. But the federal law says if you're in a state that already has an eviction moratorium law, and the state law gives tenants more protection than the federal law, then the state law supersedes. Well, California law basically gives tenants more protection. You know why? The federal law ends end of the year. The state law goes beyond that. The federal law doesn't protect you as a tenant if you make more than $99,000 a year. The state law protects you no matter how much you make. And under the state law, on January 1st, you can evict the tenant if they haven't paid the back rent. In California, as I just told you, you can never evict the tenant based on not paying this rent other than the 25%. All you can do is sue them for the money. Okay? So, sorry about that, but that's the way. Sorry about that, landlords. Is there anything good for landlords going on? One thing. This applies to landlords or anybody. Let's say you have a mortgage. Let's say you're falling behind on your mortgage because of COVID. You have a loss of income because of COVID, or you have increased medical expenses because of COVID, you're taking care of someone, whatever. If you have a COVID reason why you can't pay your mortgage right now, or you can't pay all of it, the lender has to give you something called forbearance. That's a fancy word for delay. Lender has to allow you to delay those mortgage payments. How long do they have to allow me to delay? It depends on your situation. Now, what I just told you is the law for federal lenders, FHA loans, VA loans, or any conforming loan that's Fannie Mae, Freddie Mae purchase loan. They have to grant you forbearance. Depending on your situation, sometimes that means you can restructure the loan. Sometimes it means you don't have to make the payments until the end of the loan. Sometimes it means you got 12 months to make the payments. Sometimes it means you don't have to make the payments till you actually sell the property. It depends on your situation. But what happened 2 weeks ago is good news. The state of California said these rules now don't just apply to federal lenders, they apply to all California lenders. So even if you have like a jumbo loan or some non-federally related loan, the lender still has to allow you forbearance if you have a COVID reason you're not paying. And maybe the COVID reason you're not paying is because you have a tenant who's not paying you the rent based on COVID. Well, under these new rule, what rights do I have? Once again, it depends. In other words, the California lenders are supposed to follow the same guidelines that the federal lenders are following, that not federal lenders, the federal servicers, servicing a federally related loan. Doesn't matter where it originated. So that's some good news. Talk to your lender about that. That's really the only good news for landlords. The other good news for landlords is landlords are now protected under the so-called Homeowners Bill of Rights, which says if you're in foreclosure, you have certain rights. Lender has to establish a single point of contact. They have to tell you about all of your rights. While they're negotiating with you, they can't proceed with the foreclosure. Anyway, this used to just apply to owner-occupied 1 to 4. Now it also applies to landlords who have up to 3 rental properties with up to 4 units each. Anyway, all right. Last thing about this, I know some of you don't even care about rentals, but it's important stuff, and then I'll go on to other stuff. What about local laws? I'm in LA. LA has this real strict eviction moratorium, Berkeley, San Francisco, Oakland. What takes precedence, the local law or the state law? And the answer is it depends. Here's an example. Los Angeles City, where I am right now, says not only do you not have to pay your rent if it's COVID related, you don't even have to repay the rent until 12 months after the local state of emergency expires. So LA still has a local state of emergency. So under the LA law, forget suing them in March for all the back rent. Supposedly you can't sue them until 12 months. You can't even start suing them till this state of emergency expires. And even then you have to wait 12 months. Here's what the state law says: we're overruling all of these local laws to the extent that no matter what your local law says, you have to pay back the rent on March 1st, unless your local law gives people extra time to pay, in which time you still have that. So in LA City, believe it or not, tenants don't have to pay their rent. Doesn't really matter anymore when the state of emergency ends. Starting March 1st, they have 12 months after that. So in LA City, I can't evict anyone for non-payment of COVID rent until March of 2022. So hopefully not many of you are landlords in a city like that. Oakland, San Francisco, Berkeley, they may have strict rules like that too. You have to check, or we can check for you if you call the hotline. There's LA County is different. LA County says the state of emergency, when it ends at the end of October, then you have to start paying. So in LA County, as opposed to LA City, for example, I know you don't care about LA, but I'm just giving you examples, so it might work similarly for where you are. They have to pay it all back March 1st. If your city doesn't have a crazy eviction rule like that, everyone's got to pay it all back by March 1st. On March 1st. If they don't pay it on March 1st, you can sue them for the money. But you can't evict them, you can sue them. In LA City, you can't even sue them for the money until March of 2022. Crazy, complicated. That's what we're dealing with right now. All right, let's talk about other stuff. Other stuff is happening, believe it or not. What else is happening out there that I need to know about? Let's talk about COVID real quick, just to tell you nothing has changed. People keep asking me, when am I going to do open houses? Not yet. When do I have to stop wearing a mask when I go in a house? Not yet. When do I have to stop cleaning the property after each? Not yet. All I can tell you is nothing is changing. It's going to change at some point, but we're still where we've been the last few months. Showing agent is responsible for cleaning after each showing. Everyone submits a PED form before you enter. Wear a mask, don't touch, stand 6 feet apart. Showing agent, make sure you bring extra masks and hand sanitizer if people need it. Make sure you open all the doors, open a one window, weather permitting, fires permitting, and turn on all the lights. None of that has changed. No open houses, everything's appointment only. A couple of other things to remember. If you allow people into your real estate office, you have to keep track of who's coming in and make them wear a mask and wash their hands. Why do you got to keep track of them? Let's say someone comes into your real estate office and 2 days later they call you back and say, you know what, I didn't know it at the time, but I just tested COVID positive. I thought I'd better tell you. Now you, in the broker in the office, have to try to contact everyone who came into the office after that person to tell them you were in the office after someone who was sick. See what I'm saying? That's why you got to keep track of these things. This is why listing agents have to keep track of people who come to their who show their listings. That's why you get these PED forms, so you can keep track of this stuff. Because if the seller all of a sudden says, I just tested positive, you got to go tell everyone who came into the property, in the last 14 days. Or if a buyer tests positive after they were in there, you got to try to go back and notify everyone who was in the property after that person. You see what I mean? I mean, this is not voluntary. You actually have to do this. What if you're just having meetings in your office with just your own people? Well, then you don't have to wear a mask, but keep 6 feet apart. It's probably a good idea to wear a mask. But if you allow other agents from other offices or clients into your office, that's when you have to keep track of them. And everyone has to wear a mask when they're in the office, right? Everyone. Even if you're more than 6 feet away, if there's non-office personnel there, everyone wear a mask and keep 6 feet apart and sort of log them in, okay? Difficult stuff. It's going to be over eventually, but this is what we got to deal with. What else should we talk about? What about the agent's kids? Michelle asked, you know what? If they're younger than 2 years old, no, or younger than 5. You know, I got grandkids. I got a 3-year-old. He loves wearing a mask. Where's my mask? He says, give me my mask. I love my mask. I'm sure all kids aren't like that. There's no particular rule about the age of the kids that means you don't have to wear a mask. I mean, it is what it is. It says kids don't have to wear masks. I don't know how that's defined. Anyway, let's talk about some other things. We can come back to this if you want, but let's talk about things that have nothing to do with COVID. How do you like that? First of all, are there any other forms that have come out? Well, there are 2 forms that came out in June. One's coming out in October and one's coming out in December. I'll tell you about those. This is in addition to the eviction forms I just told you about. In addition to those forms, 2 forms came out in June. I don't know if you saw them yet. One is called the Square Footage Lot Size Advisory, SFLS, the Square Footage Lot Size Advisory. Did you know when you have a listing, you have to disclose what you think the square footage is to the buyer? You notice I said what you think it is based on what somebody told you. The listing agent, it is not your job to measure the house, and I wouldn't do that. But the buyer's going to ask you what the square footage is, and you're going to tell them, well, according to blah, 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 this is the square footage. Well, now there's a nice form to do that on. There's a nice form where you can say, this is the square footage according to the assessor, according to the appraiser, according to the seller, according to the builder. And by the way, if you're aware of different opinions, if you know that the assessor thinks it's one number, but the seller thinks it's a different number, you got to put both numbers down and you have to identify who said what. And that's what this nice form does for you. It's not a mandatory form, but it has a nice chart that you can fill in to disclose what the square footage is. By the way, there's no such thing as official square footage. Anybody can have an opinion. No opinion's right, no opinion's wrong. You just have to disclose where it came from, okay? Same thing with lot size. You might not even know the lot size. Buyer says, what's the lot size? I have no idea. You don't have to know it. But let's say somebody told you, yeah, this lot size is this. You're going to tell the buyer what the number is, and you're going to tell them who told you. The good thing about lot size opposed to square footage is if the buyer wants to, they can get a survey. And a survey, that is an official lot size. There's no such thing as official square footage, but there is official lot size. That's a surveyor. But you don't have to get a survey. Okay? All right. Second form that came out in June is another not mandatory form that's a good form that protects the listing agent. It's called the Property Viewing and Open House Advisory, PVOH, Property Viewing Open House Advisory. I know what you're thinking. It has the word open house in it. I guess that means open houses are okay, right? Nope, they're still not okay. But this is a form, basically, the idea is this. You have a house for sale. People are going to come to the house. Sometimes they go in the house and they slip and fall. And they accuse the seller or the listing agent, you should have told me that the floors in the kitchen were so slippery. You should have told me about that bump in the carpet. You should have told me about that step down into the family room. You should have told me in the backyard there's this rock there that's hard to see and I tripped over it. You should have told me the seller has hidden cameras and took pictures. And then they sue the listing agent and they sue the seller. And you didn't even know about it. Well, the good thing about this form is you give it to the visitor of the property, and when they sign the form, they are assuming the risk. They're saying, I will be careful when I go in the house. I understand the risk. I'll be careful. I understand there might be hidden cameras. I understand the floors might be slippery, etc. Now, obviously, if you know as a listing agent about a dangerous thing on the property, you have to tell them. But sometimes you just don't know, or the seller doesn't even know, and something bad happens, and they accuse you of you should have known. Why didn't you know? Why didn't you tell me? So anyway, it's a good form. Okay. By the way, these hidden cameras I was talking about, you know, these rules about COVID, about, you know, when you're inside the house, wear the mask, don't touch, wash your hands, clean, wipe down the showing agent, wipe down the property after each showing. And some people say, well, I'm not going to follow these rules. So who cares? Nobody cares. Nobody's watching. I'll do what I want. We're starting to see the cases where the sellers have the hidden cameras on, and they see exactly what's going on in their house during the showing. People are sitting down on the couch right next to each other and having a meeting. People are not cleaning. People are not doing things, and you're dead right there because it's on camera. Just be careful. And the DRE is starting to get involved in this stuff too. So anyway, something to think about. All right. So those two forms came out in June. Last week, that NTRA form that all landlords have to give all residential tenants behind in their rent, if they've been behind in their rent starting in March. By the way, what if I have a tenant who was behind in their rent in February or January, and the courts were closed, so I couldn't evict them? You can evict them now. You can give them a 3-day notice to pay the February or March rent. But if they pay the February or March rent now, obviously you can't evict them. What if they say, I have a COVID reason, I can't pay the February rent? Too bad for you. That didn't start till March. So you still can evict for pre-March problems. All right. And then, of course, today, all those 15-day notices came out, and the declaration came out, and the cash for keys form came out. There's another form coming out in October. It's called the Fair Housing Advisory. Is it a mandatory form? No, but it's going to be pre-attached to all purchase contracts, all listing forms, all lease forms, and all buyer broker contracts. So you can't avoid it. It's going to be there. It's a good form. It protects you, the realtor, because it advises your clients of all the fair housing rules and what they should do and should not do. So they can't come back later to the realtor and say, you didn't tell me I shouldn't do that. Yeah, I did. It was on that form. So it explains the basic fair housing rules that everybody needs to follow. Now, there's an interesting section on that Fair Housing Advisory talking about something that a lot of people do that they probably should really think about doing, and that's these buyer letters. You're in a competitive situation. Some buyers, they don't just submit an offer, they submit a letter with the offer. Some people call it a love letter. They're telling the seller why they should pick me, because we're special, we're nice, we really like your house, blah, blah, blah. And here's a picture of our nice family. You should probably sell to us. This is a very risky thing to do, because sellers under the fair housing law are only supposed to, they're only supposed to base your decision to sell on objective criteria. How much money was owed, what is offered, how much is the deposit, how much is the down payment, what's the financing, what's their credit score, what's their income, things like that. Not that you should care about so much of that stuff, because you're getting a loan anyway. Anyway, the point is objective criteria, things in the offer. You're not supposed to base your decision to sell based on personal characteristics of the buyer, like whether they have kids or not, whether they're married or not, how old they are, how young they are, what race they are, what religion they are, whether they have a disability or not, what profession they have. I hate lawyers. I'm not selling to a lawyer. I don't blame you, but the point is you can't refuse to sell to someone on that basis. So if the buyer submits a letter and gives it to the seller now knows personal things about this person. So let's say they sell to this person rather than a different person. And this other person says, I know why they sell to them rather than me. I mean, my offer was just as good as their offer, but I'm not the right religion. I'm not the right race. I got kids. They don't like kids, or I don't have kids and they like kids. I'm too old. I'm too young. You know what I'm saying? Now that, so the seller's being set up maybe to be accused of making their decision to sell not based on objective criteria, but based on personal characteristics of the buyer. Some seller says, I can sell to whoever I want to. And that's not true. The fair housing laws do not allow you to do that. You can't, I mean, you can sell whoever you want to based on their objective criteria. For example, you could take someone with a lower offer because it's all cash. You like that, right? You don't have to take the highest offer, etc. But sellers cannot make their decision, just like landlords can't make their decision based on personal things. If I were a listing agent, I wouldn't show these letters to my seller. In fact, I would discourage buyer's agents from submitting them. Because you know what? If it comes in with this, if it comes in with the offer, I'll tell my seller, I don't think you should read this. Seller says, give it to me, I want to read it. So I can't convince my seller not to read it, even though that's potentially setting themselves up. Maybe it's better to try to discourage the buyer's agents from even submitting them. Just something for you to think about. And this is on the Fair Housing Form. A couple good questions. Remember I was talking about the hidden cameras? And the question is, does the seller have to disclose that? If I had hidden cameras in this house and you were coming to my house, am I required to tell you that I have hidden cameras in my house? And the answer is no. I don't even have to tell you. Now, if I'm listing my house and I signed a CAR listing contract with you, the listing contract says I have to tell you, according to the listing contract, whether I have hidden cameras. But there's no law that says I have to do it. So if I don't tell you, big deal, I'm violating the listing contract. There's nothing the buyer can do to me. And I film them without their permission. So I don't need permission to film you in my house. This is my house. You should assume I have hidden cameras. And they should, sellers under the listing contract, sellers should disclose that. They're required to under the listing contract. They're not required to do it under the law. By the way, there's one exception to this. This sounds like a joke, but I'm serious. You're not allowed to have hidden cameras in the bathrooms. Or unless, if you do that, you got to tell the people that are coming. It's probably not a good idea to have hidden cameras in the bathroom, just as a general thing. Yeah, so disclose the Ring doorbells. Under the listing contract, I would disclose it anyway, okay? Someone asked me, can you have trick or treat this year? I don't know about, I forget if it's statewide or countywide, but LA banned trick or treating this year. I don't know if the whole state did. You gotta check, I'll check that for you.
From my understanding, they did. I saw something.
The whole state, right?
Yeah.
Yeah, I think it is the whole state. I think it is the whole state.
But
by the way, someone sent to me, I thought lawyers were not a protected class. They didn't used to be, but now there's a protected class called source of income. So you can't discriminate against someone based on how they make their money, which means you can't discriminate against lawyers based on how they get their money. Sorry about that. By the way, there's a new protected class this year, which I think we're all glad about. Veterans and military are protected. Why would someone ever want to discriminate against military? Well, they don't like VA financing. They'd rather take a conventional loan rather than a VA loan as a seller. You can't do that. You can't turn someone down just because they're VA financing. Or landlords. I don't want to rent to military, nothing personal, but military guys get called up and they leave right in the middle. I got to let them out of the lease. I don't want to have to deal with that. Well, you have to deal with it now because you can't discriminate based on someone's military or veteran status. Okay, all right. So that's the latest on fair housing. Remember, there's something else going on this year called workplace harassment. Up until this year, it was illegal to have sexual harassment in the workplace. You know that. But other type of harassment was okay, believe it or not. In other words, you could call someone names in the office and they couldn't sue you. You could call someone, you big stupid dummy. They couldn't do anything about it. Believe it or not, you could even use derogatory racial or religious language in the office. Hopefully none of you ever would, of course, but it wasn't against the law. Now it's against the law. So you guys should all know in your workplace, none of you guys on this call would ever do anything like that, but you should know in the workplace, you got to be careful about, how you talk to people. The unfortunate thing for realtors is, what's the realtor's workplace? Planet Earth. You're working everywhere. It's not just in your office. So when you're working, which is pretty much, if you're breathing, you're probably working. Don't be careful. I mean, treating other agents, clients, vendors, anyone out there in the world, real estate, no harassment, no mean language, blah, blah, blah. Another reason I'm telling you this is, if you work for a company that has at least 5 people working there, including independent contractors, anyone in that company who's like broker, manager, supervisor, owner, you're required to take a 2-hour class on these rules. And if you're a W-2 employee of this company, you have to take a 1-hour class. These classes are available at car.org, our website, or you can go to the Department of Fair Housing and Fair Employment and Housing, DFEH website. You can take it online, but you got to do it by the end of the year if you haven't done it already. Now, if you work for an office that has less than 5 people, nobody has to take this class, but the rules still apply. Or let's say I'm an independent contractor. Independent contractors do not have to take this class unless you're also a manager or a supervisor or a broker. But it's not a bad idea to take this class anyway if you got 2 hours to kill online, because the rules dramatically changed this year. I mean, I'm a manager at CAR. I have to take this class every 2 years. I just took this year's version. I was like, whoa, that's a lot different than the class I took 2 years ago, because it has all this workplace harassment stuff that has nothing to do with sexual harassment. It's not a bad idea to take or just remember to be nice to everybody, okay? And then you'll be fine. All right. One more form coming out. So June, we had the square footage form and the property entry form. Advisories, not mandatory, good forms. This month, we have these new 15-day notice forms, which you have to use until February, and the declaration that goes with it, and the disclosure form you must give to all tenants behind in their rent by September 30th, and the nice cash for keys form. Then October, we have this not mandatory fair housing advisory that's going to be pre-attached to everything. And then the last form of the year is going to come out in December. It's called the Home Hardening and Defensible Space Disclosure and Addendum. This is very relevant in the unfortunate situation we're in now with all these horrible fires. This is a mandatory disclosure form if you're selling a house in a fire zone. And not making a joke at all, most of California seriously is a fire zone. So you're selling a property in a fire zone. This is a form you have to give to the buyer. What this form does, it educates the buyer on what they're supposed to do to make their house as safe as possible in the event of a wildfire, like defensible space and certain type of roof to prove and things like that. But this form also has a portion of it where the seller has to disclose on the form, what material is their roof made of? What type, do they have single pane or non-tempered glass windows? Do they have metal or non-combustible gutter covers? Things like that. So part of it is disclosure information from the government, and part of it is the seller has to answer these questions. It's a mandatory disclosure form. It's coming out in December. It won't be required till January, and it's only required if the property is in a fire zone, which you find out from the NHG report. There's no such form for landlords to give tenants at this point. Larry, I skipped your question. If you got commercial tenants, you can do whatever you want. There's no restrictions on evicting commercial tenants right now. I mean, obviously, if they're on a lease, you got to wait till the end of the lease. But other than that, there are no restrictions on commercial right now. Okay? All right. So you're good with forms. You're good with evictions. You're good with fair housing. And that's the latest on COVID and the masks and making sure you disclose when people are sick. What else should you be knowing about right now? Well, you know how there's this new law that defining independent contractors versus employees, and it's a very strict rule, but fortunately realtors are exempt from it. So you're still independent contractors. But you know, like Uber and Lyft right now, they're supposed to be employees and they're fighting it, blah, blah, blah. Well, good news for you, any of you or your friends are appraisers or home inspectors. Appraisers and home inspectors are now treated like realtors in the sense that they don't have to come under this strict new definition of what's an independent contractor and what's an employee. If you have questions for the details of this, call the legal hotline. We can help you. So that's good news. Remember, though, that transaction coordinators are not exempt. If you got a transaction coordinator who's licensed, you're good. But what if I got a transaction coordinator who's not licensed? Well, they better have an independent business license. Because if you got a TC working for you and they don't really have their own independent company, they're just working for you and they're not licensed, you got to treat them as an employee. You can't just pay them per file. They have to be an independent entity, or easier yet, if they're licensed, you're good. Then they come under the licensee exemption. But be careful about, and what about a personal assistant? They're almost always employees. Because unless you're not going to tell them where they have to sit and what hours they got to work. I mean, if they're just doing clerical work, fine. But if you tell them where to do it and when to do it, that's an employee too. Like I said, if you have detailed questions on this, call the hotline. A couple more questions before I go on. The PED forms. Okay, so there's the PED V for visitor and the PED S for seller or occupant. The person who lives at the house, whether it's the seller or the tenant, they sign the PED S and give it to the listing agent. So the listing agent, you don't have to give it to every single buyer who shows up, but if they ask for it, you're going to show it to them. And obviously, if the seller's health condition changes or the tenant's health condition changes, they're going to have to give a new PED S to the listing agent. What about the PED V? That's for visitors, buyers, buyer's agents, inspector, appraiser, contractor, stager, someone visiting the property during the listing. You provide the PED V, and it should be signed the day you enter, or at least the day before, just in case your health situation changes. But what about the listing agent? Well, you know what, listing agent? You're a visitor. You're not an occupant. So you, the listing agent, I mean, before it's listed, during the presentation, these rules don't apply. But once you have the listing, it's a listed property, the PED form is required. So maybe you, the listing agent, don't go back to the property very often. But every time you do, you're going to do a PED V because you're a visitor, right? Do you need a PED form for vacant land? Well, I'm going to give you the legal answer and the logical answer. The legal answer is there's no exception for vacant land. But really, you need a PED form to enter? You're not entering anything. What are you entering? You're going into the outside. You're still outside. Common sense would say you don't need to do a PED form on a vacant land listing. Having said that, I got to put on my lawyer hat, my conservative lawyer hat, and say there's no specific exemption for vacant land. So my official lawyer advice is, yes, do a PED form even if it's vacant land. I can't imagine there being a problem if you don't, but I can't say you don't have to do it, right? By the way, no one has to initial the PED form before the buyer. Here's how the PED V works. Supposedly what's supposed to happen is if you're a visitor, you submit the PED form to the listing agent before you come into the property. Hopefully not the day of, hopefully not, you don't bring it with you to the appointment, you send it before the appointment. Is it required that the listing agent initial it and send it back? Well, the law doesn't say that, but I'm concerned that the DRE says anything your client signs needs to be kept in a file for 3 years. So, yeah, buyer's agent, I would ask the listing agent to return the buyer's PED V. But isn't it enough if I, the buyer's agent, as long as I keep in the file the one that I sent, do I really need the listing agent to acknowledge it and send it back? And the answer is no, not really. You need a PED form in your file, but if your buyer signed it, the other side, they don't need to sign it. Now, some of you want to be over careful, then if you want them to send it back, listing agent, you're required to send it back. Maybe the buyer wants proof. I want proof that they actually received my PED form. I mean, if you're dealing with a good listing agent, they're not going to let you in unless you submitted one. I hope I didn't just confuse you. I'll say it again. It is not required that the listing agent sign the buyer's PED and send it back. What's required is the listing agent keep that in your file for 3 years, and the buyer's agent keep a copy of the one your buyer signed before you sent it in your file. And if you want to be over careful and you say, you know, I want proof that the listing agent actually received it, you're absolutely entitled to say to the listing agent, sign it and send it back. And they have to do that if you ask them to. Maybe it's better practice, just everybody do that. You don't have to worry about this. But remember, I always have to answer the pure legal question, is it absolutely required? And the answer is no, not required that it be returned, okay? I think it's a good practice, not required. Ideally, as I said before, the PED form is sent. Ideally, you sign it the same day you come in. People say, can't I just send it 10 o'clock the night before for my 9 o'clock appointment? Yeah, that's probably okay. As long as the buyer doesn't get symptoms overnight and start coughing and getting a fever overnight, then you'd have to update the PED form. That's why you want to do it as close as possible to the entrance, right? Makes sense, right? Okay. What else is going on? You know what else is going on out there? Most of the places we talk to, there's a lot of multiple offers going on, competitive bidding on properties. And I told you about the love letter thing. Another thing is we're seeing is buyers writing an offer that says, my offer is $5,000 more than the next best offer you get. Is that legal and enforceable? Yes. Of course, it's dangerous, right? Because that means someone else makes a really high offer, way above market. Your offer is now $5,000 more than that. And if you made a non-contingent offer at that price, they just accept it. If you don't buy it at that price, they'll probably take your deposit. Well, can I just put on my offer my offer is $5,000 more than the next best offer with a cap of whatever. Okay, great. You know what a seller's going to do? If I were the seller, I'd counter you back at the cap because I know you're willing to pay that amount, you know? And what about this? What if listing agent gets 2 different offers from 2 different buyers? Each one says, my offer is X amount more than the next best offer you get. Since you got more than one, they cancel each other out, and neither one is a valid offer. So I'm not saying you can't do this. I'm just saying, think about it. It doesn't always work the way you want it to. You know what the latest thing we're seeing? Offers that says, my offer is the appraised value plus $10,000. You're going to do that, you better be very careful about whose appraisal are you talking about? Which appraisal? And what does that mean? Does that mean if the buyer can get a real low ball appraisal, the seller has to reduce the price to whatever that is after they accept the offer? Does the appraisal have to be done before the offer is accepted? In other words, it's possible to do this, but I would get a lawyer involved, get my client to get a lawyer involved to draft it very carefully. We don't have any standard forms to do this. You know what else I see? I see offers where buyers said, my deposit is non-refundable, or my deposit will be released in escrow 5 days after you open escrow, or something like that, non-refundable. Buyers obviously trying to make their offer look better than other offers. Even if the buyer agrees to that, even if the buyer releases the money, that's not enforceable in California. On residential, you can't have a non-refundable deposit. You can have a liquidated damages clause, which sort of works the same way, right? Liquidated damages clause, that means if the buyer removes their contingencies and then they don't close, and they've signed liquidated damages, the seller can keep their money. But that's different than saying, I'm going to release my money automatically, or I say it's non-refundable no matter what happens. Because under liquidated damages, the buyer can always say, no, I'm not in breach of contract. No, I disagree with you. I should be able to get that money back. If you do a non-refundable deposit, the buyer's saying, I'm giving you the money no matter what. You can do that in a commercial context. In residential, the court won't uphold it. I'm just saying that, okay? Getting back to questions here. Do you have to have your license number on your name tags? Very good question, no. Not business cards, yes. Name tags, no. Why? That's the rule. I don't know if there's logic behind that, but that's the rule. As a seller, wouldn't you want to know who's going to enter the property? The only way to know that is to have the seller acknowledge the P. In other words, I get what you're saying. In other words, just because they sent a PED form to you, that doesn't necessarily mean they're going to enter, right? But I'm saying even if the seller initials it and sends it back, you still don't know if that particular buyer actually showed up and went in. I think all you can do, I'm assuming the listing agent's not actually there checking people in, right? I mean, if you're there checking people in, then it's real easy to know who was there. But I think if you're in one of these situations, you're the listing agent and you're not at the property, and there's a showing and someone's there and they tell you 3 days later they're sick now, you're going to go notify everybody who submitted a PED form after that person did 3 days ago. I know what you're saying. Well, how do I know they actually were there? They submitted the PED, maybe they didn't show up. Just assume they showed up and try to notify them. Or like I said, if the listing agent's actually there checking people in, or the seller's actually there keeping track of it, then you would know. By the way, that's why you want an address on the PED form. So that's showing that they were planning to visit that particular property on that particular day. If you just put random, you know, this is for any property in Placer County or something, that doesn't prove that they were in that particular property, right? Rachel's asking if the seller requests to confirm or view. Yes, seller has every right to confirm the PED forms before they allow anyone in. Sellers can do whatever they want as long as they don't discriminate, right? Or Patty, good point, link the lockbox to your listing. There are ways to do it. The point is, now more than ever, as a listing agent, you really want to keep track of who's coming into the property while it's being shown. Another question we're getting asked a lot now is it okay to do door knocking? Or is it okay to drop flyers off? Okay. Rule number one, when a property is being shown, you're not allowed to leave any paperwork behind, whether you're the listing agent or the buyer's agent. No paper should be brought to the showing. No paper should be left at the showing, even outside in the flyer box. That's rule number one. Well, what about, how does that apply to properties that are not listed? So it's not a listed property. I just want to walk through the neighborhood, dropping off my flyer in the flyer boxes on these other properties. Is that prohibited? The law does not specifically prohibit that. Some would argue, though, if I'm not allowed to leave a flyer at a listed property, why should I be allowed to leave a flyer at a not listed property? I haven't seen any cases on this, and I will tell you, as your lawyer, the law does not specifically prohibit you from dropping off flyers at the property that's not listed. I'm just worried about someone comes after you and says, well, it should be, I'm sure the implication was that the rule that you can't leave it at listed properties, I'm sure means that you shouldn't have dropped off flyers at non-listed properties, and some judge may agree with you and fine you. By the way, finally, after all these months, the Department of Real Estate is starting to get more involved in this stuff. People always ask me, if I see someone violating the rules, who do I complain to? And the answer has always been, number one, call local law enforcement. They probably don't care. Number two, can I call the California Department of Public Health? Yeah, but they're not going to send anybody out. But the DRE is actually starting to get involved in these cases. And the number one incentive to follow these rules is, number one, it's for everybody's health and safety. And number two, you're going to get sued if someone sees you. You can get sued by the client. And the clients have these hidden cameras. I'm telling you, it's happening. So anyway, just wanted to tell you that. Okay. Does notifying the buyer's agent suffice as notification if a seller or occupant's COVID status change post-showing? In other words, buyer and buyer's agent came into the house. Okay, buyer number one comes into the house. A few hours later, a different buyer with a different agent comes in. A couple of days after that, the first buyer tests positive, tells the listing agent. Is it sufficient for the listing agent to tell the second buyer's agent, or do they have to tell the buyer as well? You really got to try to notify everyone who came into the property separately, okay? Okay, I see you guys have some internal stuff going on there. That's good. Let's see, what else? Oh yeah, door knocking. Door knocking you can't do. That's not a gray area. Door knocking right now is still violating the stay-at-home order. It doesn't violate the Cal OSHA or guidance. It violates the original stay-at-home order, which is still in effect, the one that said you guys are essential, the one that allows you to work. That one is still there, though, and that one is the one which doesn't allow door knocking. So this is all going to end one day, but right now, right now, that's what you. What about mailing things through the U.S. mail? That's fine. I know some people are going to say, what's the difference between mailing it in the U.S. mail and dropping off a flyer? Good point. Remember I said the dropping off a flyer thing is not specifically prohibited. I'm just worried about someone arguing that that's similar to dropping off flyers at a listed house. Mailing is perfectly okay, definitely. Remember the concept here is we're all trying to minimize personal contact. We're trying to do everything virtually as much as possible. course, the real estate profession is very much a profession that has always involved a lot of personal contact. And it's a very challenging situation you're in right now, but you got to do the best you can. It's my job. All I can do is tell you what the rules are, right? That's all I can do. Let me talk about one more thing until Michelle cuts me off. But one more forms issue to know about. So I told you all the new forms, right? Not that many this year, but there's one form that's not new that you've all been using for 34 years. Those of you that have been in business as long as me. This is my 35th year. And there's a form that came out 34 years ago called the Transfer Disclosure Statement, the TDS. We're all familiar with this form. We use it, you use this form more than any other form other than the purchase contract. I vividly remember the day it came out and said, wow, all of a sudden sellers have a disclosure form. Up until then, it was let the buyer beware. No more buyer beware, you got to disclose stuff. All right. When that form came out 34 years ago, just like today, it's a 3-page form with 4 sections. Section 1, 2, 3, and 4. First page, section 1, it's called, the subheading is Substituted Disclosures. Section 2 starts at the bottom of the second page, and it's the first page, and it's the whole second page. That's seller disclosures. Last page are the 2 agents' disclosures. Everyone understands section 2 and 3 and 4. Seller fills it out, agent fills it out, agent fills it out. But what about section 1, substituted disclosures? For 34 years, realtors have asked me, what about section 1? And for 34 years, I've been telling realtors, just skip it. Because here's the concept of that. The only time you're really going to use section 1 is if the seller is going to hire somebody to provide a substituted disclosure so that they don't have to answer their own questions on section 2. I don't think in 34 years I've ever heard of a seller other than an REO who says, I don't want to answer these questions. I want to hire someone else to answer these questions. And you know why that is? You know, look at those questions. Those questions all ask the seller, hey seller, are you aware? Has something ever been done on the property without a permit? Are you aware of neighborhood conditions or something like? It's not asking, they're not asking if it's true, they're just saying, are you aware? And I think when they drafted this law 34 years ago, the government thought maybe sellers would hire people to check the permit situation. But sellers figured out a long time ago, I don't really need to do that. I'm just going to answer these questions honestly, yes or no, to the best of my ability. I'm not going to pay somebody to do a substituted disclosure. Some people say, well, isn't the NHD a substituted disclosure? Because if I didn't have an NHD report, wouldn't I have to put those zone disclosures on the TDS? So isn't it substituting for something I would already have to do? No. Substituted disclosure seriously just means substituting for the seller's specific disclosures on page 2. Like I said, so bottom line is, for 34 years, I've been telling realtors, unless the seller is actually hiring someone to answer all the questions for them, and the seller is not going to answer the questions themselves, skip section 1. I can't say that anymore though, because they changed the law this year. The law now says the TDS is not complete unless every section is filled out, including section 1. So now everyone in the world looks at me and says, well, how do I fill out section 1? What box do I check if I'm not substituting any disclosures? Fortunately, there's a new checkbox on section 1 that says no substituted disclosures attached. So please check that box every time. Then you've satisfied the new law that says you have to fill out every section. See that? I know it's difficult, but yeah. Yeah, Laura, listing agents are not supposed to put flyers on the box on a listed property. Mailers are fine. Yes, try to be digital as much as you can. We're all going to come out of this at one point or another better, but these are the rules we got to deal with. And I think, Michelle, that's about all I have.
Okay.
Oh, one more discrimination thing. You can't discriminate if you're a landlord, you can't discriminate against Section 8 anymore. You used to be able to say as a landlord, I do not take Section 8 tenants. Can't do that anymore. I mean, you can take another tenant who has better objective criteria than the Section 8 tenant. But if your Section 8 tenant has the best credit score, the best income, the best eviction record, and you take a tenant who's less good and you take them because you don't like Section 8, you could be in trouble. You can't refuse to take Section 8 tenants just because they're Section 8. Okay? Now I'm done, Michelle.
Gov, we totally appreciate you taking time out of your very, very busy day, educating us over and over and over. Because sometimes we need to hear it more than once, maybe even more than twice. Just saying. I know I need to hear it more than twice sometimes.
I hear you.
Really get it in and understand everything in my head here. So what I would like to do is actually probably get you back in the first of the year. Is that okay? All right. I'll have Alyssa work on that with you.
As long as I'm trapped at home, I come in all the time, you know?
Yep. I appreciate you. So thank you so much.
All right. We'll see you next time.
Everybody. Bye. Thank you. Everybody, I want to let you know we will be releasing the next contest here shortly. It'll be going out for the fourth quarter, and it's going to be for buyers and listing agents. And we all know Richard Mahoney totally loves this computer, loves it. And everybody else is enjoying the other little prizes that we had. So if you can just text me, email me, give me some ideas what you guys are thinking for the different prizes, because I know what ideas I have, but it's not me who's going to be winning, right? So let's see what you are enjoying. If there's a guest speaker that you would like to have on one of our team meetings, share with me, let me know. Right now, at this very, very minute, we have Zach going over command. So you can jump on. There's a link that the girls just sent out. So I encourage you to go on. And you can ask any question that you want. Let it be Facebook ads, zip forms, anything. Just get out there and ask questions, because knowledge is power. Because I'm almost 100% sure somebody else is wanting the same answer. So go out there and ask those questions. Knowledge is power, you guys. Thank you so much. Have a blessed day. Bye. Thank you.
Thank you.
Thank you. Thank you, you guys.